The Chesapeake Legal Alliance provides a variety of legal services to individuals, citizens groups, environmental organizations who are trying to work to clean up the Chesapeake Bay. Our mission is to find lawyers to help organizations that can't afford to hire a lawyer. And we do a whole variety of things, ranging from helping organize a new nonprofit and get a 501c3 designation to suing under the Clean Water Act, and as you'll see tonight, working to help control development so that it is environmentally sensitive. I don't really have to ask this group this question, why should you become involved? I assume if you weren't interested and didn't know the answer to that question, you wouldn't be here tonight. But I assume all of you are interested in protecting the quality of life in our community and the environment, and particularly in this area of the Chesapeake Bay. And the way you can do that, in part, is to help assure that development activities, when they happen, and they are going to happen, let's face it, it would be nice to adhere to Tom Horton's suggestion, save the bay, stay away. But this is a wonderful place to live and people want to come live here, and so there's going to be development. The question is, how can we make sure that development follows the law? So the purpose of my presentation tonight is partly to help you participate in this activity, to help you understand what the legal requirements for development are and what the process that is followed in development looks like, and therefore to give you some legal tools to help you work on assuring that development takes place in an environmentally sensitive way and that it serves the interest of the community and doesn't harm the community and the quality of life. Now, I should say we're going to be talking tonight about legal tools. Legal tools are only part of the kit bag. Politics, you won't be surprised to learn, is important too. Public relations is important, but those are subjects for another talk. I'm going to be talking exclusively tonight about the legal tools available to citizens who are trying to work on this in this area. We're going to start by talking about the subdivision process, how it works and how you can get involved in that process. And then I'm going to talk about some specific legal tools that are brought to play in the process. And this is a list of statutes and regulatory requirements that all developments have to follow. Now, not all of them are applicable to all developments, but when they are there to guide development. One of those is the Adequate Public Facilities Law. We're going to talk about environmental site design. We're going to talk about special exceptions and variances to the zoning laws. We're going to talk about the Critical Area Law, the Forest Conservation Act, wetlands permits, and finally, the Endangered Species Act. All of these are tools in the kit bag of citizen activists who are trying to help manage development so that it makes sense. Let's start by talking about the subdivision process, because this is where it all comes together. You all know what a subdivision is. Here's a picture of a typical subdivision. When a developer wants to start a new project, and let's assume it's a housing project, the first thing the developer has to do is subdivide the property into lots, so that when all is said and done, the developer is going to sell one lot to one homeowner, presumably. That's not always necessary. There are some large undeveloped properties that have already been divided into lots. There, the developer has to get permission for his approval of his site development plan. But the two processes are very similar and really work together. We'll talk about the approvals that are necessary for a developer to get to develop a subdivision. And we're going to talk about how citizens can get involved to protect and influence the process. Well, the subdivision process is essentially managed in Anne Arundel County by the Office of Planning and Zoning, and in most other counties there are equivalent offices. And the first formal step in the process is that a developer has to hold what is called a pre-submission community meeting, at which the developer is supposed to show up and present a description, usually a rather summary description of what the project is proposed to look like. The idea is to put the community on notice. The developer tells the community about the program. These meetings are more or less useful depending on how fulsome the developer's description of the proposal is. Some developers, unfortunately, give very little detail in the pre-submission meeting. Other developers are better and will give a fairly extensive discussion. Actually, there is an effort underway to amend the county code to require that the developer give at least a certain minimum amount of information at these pre-submission meetings. After that meeting, the developer submits a sketch plan for a subdivision, or it's called a preliminary plan if the developer is looking for site development approval for a project that's already been subdivided. That plan has a lot of elements. Obviously, it includes plans, drawings of the site, what it looks like now, what it's going to look like. And it includes the location of stormwater management facilities, a landscaping plan, a forest stand delineation, which we'll talk about a little bit more in a minute, a bog protection plan, if there are any bogs in the area, where the existing drainage for the land is and what the proposed changes to the drainage are. It has to include a traffic impact study. Are the roads surrounding the development adequate to handle the increased traffic? And there's an equivalent dwelling unit worksheet which goes into some of the calculations that are relevant to the approval process. And finally, the developer has to submit proof that he has in fact held the required pre-submission meeting. Then there is an iterative process according to which the developer and the Office of Planning and Zoning go back and forth. The Office of Planning and Zoning makes comments, the developer amends the plan to respond to the comments, and eventually they get to the stage where the developer and the county are satisfied that the plan is ready for final approval. That can take a matter of weeks, more often months, sometimes many months, before the plan is ready for final approval. The developer then holds a final community meeting at which he describes to the community what the final plan is going to look like. And then the Office of Planning and Zoning issues its formal approval, which it posts on the county website. Now that's the only public notice of approval, and that's, as we will see, a particularly important date to keep in mind. So what can you do during this process? Well, the first thing to do is get alerted that somebody's going to do a new development. And the way to do that is quite easy. You call up the Office of Community and Economic and Constituent Services in the county executive's office, and ask to be put on the mailing list, the email list, for notices of things like proposed new developments. That way you or your community association can know in advance when something's likely to happen. And then you should, if you have concerns about a major new development, attend the initial community meeting and learn about what the developer's plans are, ask questions, gather as much information as you can. And then when the developer submits the preliminary sketch plan, get a copy from the Office of Planning and Zoning. This is a document which is a matter of public record. OPZ is really quite cooperative. You can meet with the reviewers who are going through the plan, find out what the status of the plan is, what issues are being discussed with the developer, and so forth. So you need, in effect, to stay on top of the process. You monitor the progress, communicate with the county so that you will be aware when the final plan is about to be approved. And you don't have to wait to check the county website every day to find out whether the final approval has been issued. And in the course of this, you can let the county know of your concerns. And they will listen. They will meet with you and hear your concerns. And if the concerns are valid, factor them into working with the developer to try and resolve those concerns. And then, of course, you want to attend the final community meeting to find out what the final plan looks like. And this is important, you can appeal the final approval if you think it's wrong. If you think that the project does not meet the required standards, you have the right to appeal to the Board of Appeals. Now, the trick is that has to be filed within 30 days of the publication of the final approval, which is a pretty short time. And unfortunately, the Chesapeake Legal Alliance regularly gets calls from people saying, we've got a big problem with this huge development that's going in our community, and we want to appeal the final approval. And you ask, well, when was it approved? And they say 28 days ago. Well, by then, I hate to tell you, it's usually too late to find a lawyer, get the lawyer up to speed, do conflicts checks, and then in time to file an approval by the deadline. And if you miss the deadline, you're out of luck. There is no further legal recourse. Well, the appeals are made to the County Board of Appeals, and they can be filed by anyone who is an aggrieved person. Aggrieved is one of those wonderful technical legal terms. It means, in theory, that you are going to suffer in a way which is greater than or different from the way other people in the community are going to suffer as a result of this development. As a practical matter, it probably means that to have standing to file an appeal, you need to own a property which is next door to or very close to the development, or at least be able to see it, be within sight and sound. Because otherwise, the Board of Appeals and eventually the courts are going to say, sorry, you don't have standing because you are not specially aggrieved in a way different from the general public. Well, the Board of Appeals then has hearings, conducts a quasi-judicial proceeding, hears evidence, receives documents, hears testimony from both sides, and issues its decision. And if it approves the approval, then you have the right to appeal to the courts. Again, you have 30 days, and you can take it to the circuit court only if you participated in the transactions before the Board of Appeals. So in other words, you've got to start at the beginning. And furthermore, the circuit court reviews the problem on the basis of the record that was created before the Board of Appeals. It doesn't take fresh testimony. So if you haven't participated in the Board of Appeals appeal and established the kind of record you need to win, you're again out of luck. So in other words, you've got to follow this process all the way through from beginning to end. You can't come in the middle and hope to have much luck. So now let's talk about some of the specific statutes that a development has to comply with. First, there's the Adequate Public Facilities Law. It requires that existing public facilities be adequate to handle any increased load as a result of this development. roads, schools, fire protection, sanitation, water, sewer, all of the public facilities the county provides have to be adequate to support the development. As you may be aware, in Anne Arundel County, many of our schools are already fully up to capacities, indeed maybe overloaded, which means that a new development in that school district can't take place, or it, as you may know, can take place only if it's an over 50 development, presumably by people who promise not to have any kids, so as not to increase the load on the schools. And the same is true for all of the other facilities the county provides. The process for the adequate public facilities statute is that as part of the initial plan submission, the developer has to submit studies showing that the roads are adequate, the sewage capacity is there, the school capacity is there, et cetera, et cetera. Those studies and the developer's plans are reviewed by the relevant agency in the county. The Department of Public Works, for example, reviews water and sewer. Schools Department reviews the school issues. Highway Department reviews highway issues, and so forth. That process is one that is usually pretty opaque to the citizens. It goes on inside the agency, and you don't really have much chance to participate in it. If the project is determined by the developer, by the relevant agency to fall below the standards necessary for the facilities to be adequate, the developer's got to come up with a plan. The developer either has to pay the county to widen the streets, for example, put in a new traffic light, or in some cases the developers have actually built new school buildings and paid for that out of their own pockets to satisfy the adequate public facilities law. The ultimate decision on the adequacy of the final plan with respect to public facilities is made by the relevant agency, so there's not much opportunity for public involvement. However, the inadequacy or alleged inadequacy of some facilities to support this development do serve as one of the possible grounds for appeal. The next subject I'd like to talk about is environmental site design, which is actually relatively new. It only has come into effect in the last few years when planners have learned that our old way of handling stormwater, and that's what this is all about, weren't working very well. And in fact, they're causing significant damage to the bay. Environmental site design is enforced by the Office of Planning and Zoning. It's the agency that reviews the site design for the project. Again, there's not a whole lot of opportunity for citizen input. You can discuss it with the planners at the county level. But basically what environmental site design says is that environmental site design practices must be employed to the maximum extent practicable. That's what the rules say. And in general, that means getting rid of holding ponds, curbs and gutters, large impervious parking lots, and replacing them by so-called micro-scale practices like rain gardens, grassy swales, replacing curb and gutter with grassy swales, putting pervious paving in parking lots, and so forth. The criteria for environmental site design, which the developers are supposed to follow, are in a stormwater manual, which is available online. And I might mention here that these slides are available at the Chesapeake Legal Alliance website, the address of which is chesapeakelegal.org, pretty easy. Don't forget it's org, not .com, as well as a resource page which contains links to all of the statutes and regulations I'm talking about here tonight. They are available online, easy to find, especially if you use this resource page. And although they are, quote, legal, most of them are written in a way that ordinary people can understand, believe it or not. It helps to have a lawyer because some of them need interpretation, but at least you can go look at them if you get involved in one of these things and get an idea about what the rules that the developers have to follow actually look like. Now we come to special exceptions and variances. Special exceptions are particular uses that are permitted by zoning codes that are an exception to the basic underlying zoning of the area. Now, some of you know about the proposed workforce housing project up on Route 2. Workforce, that area is zoned R2, which means 2 houses per acre, but workforce housing is allowed as a special exception in an R2 zoned area. To get the special exception, you have to meet certain standards to qualify for that exception as are listed in the zoning code. Variances are a little different from special exceptions. Variances are where the developer can't meet one of the requirements of the zoning code and asks basically to get excused, to have that requirement waived for this project, which is allowed where there are, quote, practical difficulties or, quote, unnecessary hardship, whatever that means. Some developers think unnecessary hardship means I can't make as much money as I would like to on this development. Well, that's not the test, but that's the way some of them behave. And unfortunately, sometimes the county officials buy that argument. Now, there's a process for granting special exceptions and variances. Oh, yes, there are special standards for variances and special exceptions in the critical area and bog protection areas. We'll talk a little bit more about the critical area laws in a minute. So, special exceptions and variances are approved initially by the county's administrative hearing officer, currently a man named Doug Holman, who's really quite a good guy. He is an environmentalist. He listens, he's a good lawyer, and he does his job pretty well. The applicant for a special exception or a variance has to give public notice by posting a sign like the one pictured here. You've probably all seen those signs. And also mailing a notice of the request to nearby property owners, people who own property within 175 feet of the property that is under consideration. The administrative hearing officer then holds a public hearing. Again, it's a quasi-judicial proceeding. Now, anyone can show up at this hearing and participate. You don't have to have standing in the sense of being specially aggrieved. Any member of the community can show up at this hearing. The developer, the developer's lawyers will show up. The county will have a representative there to tell the administrative hearing officer what the county's recommendation is. And then the administrative hearing officer, after taking testimony, will make a decision, sometimes approving, sometimes denying the special exception or the variance. Now, people can participate in a number of ways. You can show up, obviously, and testify. You can show up and not testify as long as you sign the list. You're counted as having participated. Or you can just send in a written comment. But it's important that you do so because if you don't like the decision of the administrative hearing officer, you can appeal, but only if you participated at the administrative hearing officer level. Appeals go first to the Board of Appeals, and then, as I discussed earlier, to the circuit court if somebody's not happy with the decision of the Board of Appeals. To appeal this time, you do have to have standing and be specially aggrieved. You also have to have participated and appeared in the earlier proceedings. There are some minor relaxations of the standing requirements in environmental cases when the approval is environmental in nature, for example, approving a wetlands disturbance permit, but I won't get into the details of that now. Again, remember, the appeal must be filed within 30 days of the final decision, whether it's the final decision of the administrative hearing officer or of the Board of Appeals. So you've got to be on top of the process, and you've got to be prepared to file a notice of appeal almost immediately. 30 days is a pretty short time. Now let's talk about the critical area law. Everybody's heard of the critical area law in Maryland. Very few people really understand what it's all about, so I'm going to try and give you a short course in the critical area. We'll talk about what it is about, where it is, where the critical area is, and what restrictions are imposed on development in the critical area. The critical area law basically establishes an overlay to the existing zoning requirements. So if the existing zoning for an area in the critical area is R1, in some cases, the critical area legislation may impose a stricter, that is to say less dense zoning on top of the basic underlying R1. Just like all the other things we've been talking about, the developer must satisfy the county that he is in compliance with all of the applicable critical area regulations. And again, any objections based on the critical area have to be raised with the county and the Office of Planning and Zoning. And again, if necessary, they can be appealed to the Board of Appeals and eventually to the courts. There are three categories of land in the critical area. There is intensely developed areas, or IDA, limited development areas, and resource conservation areas. Now, IDA is areas that are already intensely developed. And right around here, there are quite a few of those. Lots and lots of houses all lined up on the water. Legacy of an earlier time. There is limited natural habitat. It's just almost all houses and streets. Limited development areas are less intensively developed. And we have examples of that in our community as well. And finally, resource conservation areas, or RCA, are not developed at all. Most of them are farmlands or forest. We still have some of those in Arundel County, a lot more of them on the eastern shore. The restrictions depend on which part of the critical area you're in. Well, the critical area has been mapped. Every county was required by the critical area legislation to map its critical area and to divide it up into IDA, RCA, and LDA. In general, it's the area that is 1,000 feet inland from any tidal water or tidal wetland. This is a picture of a part of the map which you can find online. And it's the part of the map which is right where we are now. You see the Severn River down at the bottom and the Magathie up at the top. And you will notice that some areas are green. Those are resource conservation areas. Some are yellow. Those are limited development areas. And some are orange or darker yellow. And those are intensely developed areas. You can find a link to these maps at the Chesapeake Legal Alliance website at the resources page I mentioned. So let's talk about what the restrictions in the critical area are. In the IDA, because it's already developed, there are no lot coverage restrictions. The lot coverage restrictions are whatever the underlying zoning is. If there is going to be any new development in the critical area, in an intensely developed area, the statute says you've got to make it better. You have to reduce the existing stormwater from the area by at least 10%. Now, this doesn't happen very much because if it's already developed, there's not likely to be any new development, but occasionally a developer will come in and buy a bunch of houses, tear them all down, and build a new housing development. In that case, this is what would apply. There are also some other minor restrictions which aren't particularly important here. In the LDA, the permitted density is either 4 houses per acre, i.e. quarter-acre lots, or whatever the underlying zoning allows, whichever is the more restrictive. So if the underlying zoning is R2, then that's the limitation on development, not R4, which would be 4 houses per acre. And the only uses allowed in the limited development area are those which are permitted by the underlying zoning classification. Finally, there's a resource conservation area. The uses allowed in those areas are very limited, mostly residential and agricultural. And this is the big one, again, not terribly relevant to Anne Arundel County, but the limitation is 1 house per 20 acres. And there is a loophole, however, grandfathered lots, that is, lots that had been subdivided prior to the enactment of the critical area legislation are grandfathered. And if there's more than 1 house per 20 acre allowed on those lots, that's what the developer gets to do. There are certain activities in the critical area that are not permitted. These are listed here. They're not usually terribly relevant, but there they are. There are some special lot coverage requirements, that is the percentage of the lot that can be covered by impervious surface, that are a little different sometimes from the underlying zoning, and there are special requirements for the management of stormwater. There is also something in the critical area called the buffer, which you may have heard of, and the buffer is basically the area 100 feet landward from the mean high water line of tidal water, tidal wetland, or tributary streams. If we're in the resource conservation area, that's expanded to 200 feet. And there's also something called the expanded buffer. If in the buffer, or near the edge of the buffer, there are steep slopes or sensitive areas or highly erodible soils, the buffer can be expanded beyond the 100 feet or the 200 feet. And there is generally no development that's allowed to take place in that 100 to 200 foot buffer. And if the construction requires any kind of disturbance whatever, the developer must submit a buffer management plan which shows how the developer is going to minimize the impact of the construction in the buffer area. And now we come to one of my favorites, the Forest Conservation Act. I am proud, I'll say that some lawyers who were volunteers for the Chesapeake Legal Alliance were the first ones to identify the Forest Conservation Act, at least in this area, as a huge tool for restricting development. As you may be aware, the hot burning issue right now with respect to the Crystal Springs development, which if you read the Capitol you can't have missed, is all about the Forest Conservation Act. It is a major tool for people who are trying to manage development and make it more environmentally sensitive. The Forest Conservation Act is intended basically to protect tree cover. Trees are good. They're wonderful for the environment. Someone once said, imagine a device that keeps land cool, that absorbs runoff, that absorbs nutrients, that provides habitat for animals. Well, we're describing a tree. And that's what the forest conservation is all about. And there is particular protection paid to so-called priority forests, which we'll define in a minute. In general, the Forest Conservation Act applies to any development that covers more than 40,000 square feet, which is roughly about an acre. It doesn't apply to building on a single lot. So if you have a 1 acre lot and you're going to build one house, the Forest Conservation Act doesn't apply. It is administered by the county with oversight from the Department of Natural Resources, which is supposed to provide guidance to the county about how the counties should treat the Forest Conservation Act. Unfortunately, they don't always do such a good job of that, but that's what the state's responsibility is. Priority forests are those that are adjacent to streams or wetlands, steep or erodible soils, or they are within or adjacent to any large contiguous block of forest or wildlife corridors. So anytime somebody's trying to develop something like the Crystal Springs property, which is a great example, which is mostly wooded today, that's a large contiguous block of forest. And the idea is you're supposed to preserve that to the maximum extent possible. Of course, there's a loophole. If the developer can demonstrate that the development plan, quote, cannot be reasonably altered, he can get out from under some of the restrictions of the Forest Conservation Act. Again, not clear what that means exactly. The Forest Conservation Act also protects rare or endangered tree species, those that have historical significance. Think the late Y oak, for those of you who've been around long enough to remember the Y oak. I don't know that we have any historically significant trees in Anne Arundel County, but we might. And larger trees, trees that are some fraction of the champion tree, which is defined by DNR for each species of tree. The biggest, most important tree of that species in the state is the champion tree, and if a tree is over some percentage of that size, it's to be protected. Again, there's a loophole. If the developer can show that owing to special features of a site or other circumstances, protecting the trees would result in unwarranted hardship. Again, we don't know what that means. Courts haven't really defined it. I suspect that some of the litigation that's going on about the Crystal Springs development may shed some light on this statute before long. The statute talks about afforestation and reforestation, two technical terms. Afforestation happens when you've got to put in forests that don't exist. So if a developer is, for example, going to develop a cornfield and put in a housing development, there are no trees on the cornfield. When all is said and done, the project must have a certain percentage covered in trees. By and large, it's 15 or 20%, depending on the nature of the development. Reforestation takes place if the developer has to cut trees in the course of the development. The developer may be required to plant trees somewhere else on the property to bring the total amount of forest up to the specified level. The process begins by the developer submitting a forest delineation plan. That's part of the initial application. The forest delineation plan is a map showing the location of forests, designating priority forests, indicating if there are any specimen trees, indicating other natural features like wetlands, erodible soils, and so forth. That goes to the county, which must approve it. Citizens don't usually have much to say about that. When the county approves it, the decision to approve the forest delineation plan is not appealable, like some of the other decisions we're talking about. And doing a forest delineation plan really takes an experienced naturalist or arborist, and to verify whether it's any good, you probably need access to the site, which may be difficult. So citizens don't have much of an opportunity for input there. But after the forest delineation plan has been approved, the developer has to submit a forest conservation plan. And the plan has to describe where the disturbance is going to take place, how forested areas are going to be handled, how you're going to protect sensitive environmental features, and how many trees or what percentage of the property is going to be covered by trees at the end of the process. There are some, this is, by the way, an example of the Forest Conservation Act not having been in place. I can't see a single tree on this picture. So how can you use the Forest Conservation Act? First, you can challenge the accuracy of the forest delineation plan. And the activists who are contesting Crystal Springs did that. I'm not quite sure what the nature of their challenge was, but I think, as I recall, it did make the developer go back and rethink the forest delineation plan and finally got approved. Not appealable, however. And then you can challenge the adequacy of the forest conservation plan once it's submitted. Again, you go to the county when the developer submits the forest delineation plan and say, this is no good. It doesn't meet the required standards. So you talk to the county. And then, if it's approved anyway, you have the right to appeal on the grounds that the development doesn't meet the requirements of the Forest Conservation Act. And now we come to wetlands permits. Anytime a developer wants to disturb a wetland or its buffer, and there's an area surrounding the wetland defined as the wetlands buffer, the developer must go and get a permit from the state, the Department of Environment. Now, a wetland is generally defined as any area which is wet enough at least part of the year that it will support hydric vegetation. That is, vegetation that only grows in wetlands. And that's all defined. So if the property is completely dry in August, that doesn't necessarily mean there's no wetlands there. Bear that in mind. Sometimes a permit is required from the Army Corps of Engineers under the Clean Water Act. When that's the case, the developer submits a joint application, basically the same application which goes both to the Army Corps of Engineers and to MDE. There is a subtle difference between disturbance in non-tidal wetlands and in tidal wetlands. For non-tidal wetlands, the applicant has to submit a request for a permit and must show either that the project is water dependent, for example, a marina. Obviously, you got to build a marina near a wetland. Or it is not water dependent, so it's a residential housing development somewhere a little removed from the water, and there is no practicable alternative, another big loophole to disturbing the wetlands to get the project developed. Now, actually, MDE's been pretty good about this. They are not too receptive to the argument there's no practicable alternative. And they'll say, I'm sorry, move your development. Don't put houses there. Move the road somewhere else. Build a bridge. Do something to avoid disturbing this wetland. The applicant also has to demonstrate that the project will minimize the alteration or impairment of the wetland and won't harm groundwaters or surface waters, and is consistent with a comprehensive watershed management plan if one exists. Tidal wetlands licenses are a little different. Tidal wetlands belong to the state. They are defined as the area, the water, the wetland, below mean high tide. It belongs to the state, pretty much everywhere in the state. So instead of getting a permit to disturb a tidal wetlands, you have to get a license. And the statute requires that you apply to the Department of Public Works, or sorry, the Board of Public Works, which is the governor, the comptroller, and the attorney general. That's the Board of Public Works. Now, actually, they act on the recommendation of the Department of the Environment. So as a practical matter, even though the paths that these approvals follow are different and the ultimate decision point is made somewhere else, there's not really any practical difference. The one difference for tidal wetlands is that they can, permits can be, or licenses can be granted only if it is in the best interest of the state, taking into account varying ecological, economic, developmental, recreation, and aesthetic values, or whatever that means. Federal permits follow a somewhat similar process. They're issued by the Corps of Engineers. Federal permits are required anytime anyone is going to dredge or fill in waters of the United States, a wonderful term, which is somewhat controversial at the current time as a result of a recent Supreme Court decision. EPA has just published a proposed rule which would define waters of the United States. Suffice it to say that waters of the United States are generally any navigable waterway or adjacent waterway that has a connection, a hydric connection to the navigable waterway. Now, navigable waterways means something different from what you might think. Navigable waterways means it's big enough to float a log during high water in the spring. On the theory that people used to float logs downstreams, and they were therefore navigable and used in interstate commerce, and therefore Congress had jurisdiction. So this raises constitutional issues and a whole bunch of others. We'll find out the answer to that eventually, but you still have to get a permit from the Corps of Engineers if you're going to dredge and fill in waters of the United States. The determination made by the Corps is whether the granting of the permit is in the public interest, again taking account the effect on the environment. The process is, just like all the others, the applicant submits an application, in this case to MDE and maybe to the Corps of Engineers. MDE issues a public notice, and it circulates that public notice to all contiguous property owners. So you don't have to necessarily look for the public notice in the Federal Register, which is where you, or the register published by, not the state register, or online. It's also online. But if you're following this process, you ought to know that the developer is going to need a permit to disturb a wetlands, and therefore they're going to need to go to MDE, and so you follow the process of the submission. When the MDE takes this up, anybody can demand a public hearing. Public hearing, you show up, you give testimony, you submit documents as to why this permit shouldn't be granted. The MDE has to grant or deny the permit within 45 days of the public hearing, or if there is no public hearing, within 60 days of receipt of the application. The federal process is similar. It kind of goes along a parallel track. Well, what can you do with a wetlands permitting process? Well, first of all, you ought to request a public hearing. Doesn't cost anything. You study the application, you show up at the hearing, make an appearance, testify, submit evidence, and like most of the other decisions we've talked about here, if you're not happy with the result, you can appeal, again, to the Board of Appeals. And now we come, last but not least, to the Endangered Species Act. Now, most people don't think of Maryland as harboring many endangered species, but there we have the Puritan tiger beetle, a federally designated endangered species in Maryland, located right here in Anne Arundel County. they, I gather, tend to live in eroding cliffs, like Calvert Cliffs, or for those of you who live on the Magathie, like Dobbins Island, and they must be protected. The dwarf wedge mussel also appears in Maryland, although to the best of our knowledge, there's none of it in Anne Arundel County. The Endangered Species Act puts restrictions on federal agencies, businesses, and individuals. It's administered by the Fish and Wildlife Service and the National Marine Fisheries Service. Fish and Wildlife Service for plants and animals, Fisheries Service for fish, or aquatic species. The species are designated as either endangered or threatened, and they are listed by the websites of these two agencies. You can also find a list of them on the Department of Natural Resources website. It'll show you which species are designated as protected, threatened, or endangered in Maryland, in fact, county by county, by the feds, and Maryland has its own designations. Unfortunately, its designations aren't as helpful because there is actually relief under the Endangered Species Act. What happens when somebody wants to do a development and discovers that it's in an area where it is going to jeopardize a protected species or is threatening to adversely modify the habitat for the species? And here we have two other species, the Maryland darter, another endangered species, and sensitive joint vetch, an endangered species in Anne Arundel County. So if the process is going to threaten the life of protected plants or animals or the habitat in which they live, then the federal agency that's granting a permit, like the Corps of Engineers, for example, can't grant it. The process that this works through is consultation. The agency that's being asked to grant the permit has to go to either the Fish and Wildlife Service or the Fisheries Service and consult with them. The consultation focuses on the jeopardy to the species or the adverse modification of the habitat, and whether the developer is proposing reasonable and prudent alternatives to protect the species or the habitat. And the Fisheries Service or the Fish and Wildlife Service are required to issue a biological opinion, a formal document. Says, we've studied this problem, and here's what our findings are, and here's what our recommendations are. We recommend that the approval be denied, or we recommend that it be granted. And the agency has to consider the biological opinion before it takes any action. The Endangered Species Act also has a take prohibition, kind of a technical term, means killing. I suppose capturing would do, but usually you're going to kill a threatened species. It recognizes, it says it's unlawful to take an endangered species. However, it recognizes that sometimes other legitimate activities are going to result in the unintended taking of an endangered species. And that means that the developer, in our case, has to go to the agency and get permission before it engages in these activities. They're going to kill a lot of Puritan tiger beetles, for example. And it's got to comply with whatever conditions are established in the biological opinion by the Fish and Wildlife Service or the Marine Fisheries Service. So how can you use the Endangered Species Act? Well, review the biological opinion, get help from a naturalist if you need it. You probably will. I would. Comment on it. Say, I don't think it's good enough. You can look at the habitat conservation plans established by the developer in order to protect or minimize the damage to habitat or the endangered species. And you can review and, if appropriate, comment on incidental take statements. That's these inadvertent killings that require permission. You can demand a public hearing. You can attend and participate. Provide at least written statements so you're there. And, of course, you can sue. The Endangered Species Act has a citizen suit provision to allow a suit to be brought to stop any person, including a developer, from violating the Endangered Species Act or its regulations. And you can also sue to compel the Fish and Wildlife Service or the National Marine Fishery Service to enforce the take provision. And swamp pink, by the way, is another endangered species in Arundel County. So let's wrap up. Real estate development can be managed in a way that protects the environment and the surrounding communities if citizens get involved. Every major development is subject to a bunch of county approvals, sometimes state approvals, and even occasional federal agency approvals. And developers have to meet the standards for those approvals, for each one. And the approval process provides you as citizen activists with some legal tools that you can use to influence the process and ensure the outcome is such that it minimizes or even eliminates the adverse effects on the environment and the community. In order to play that role, you've got to understand the process, which is why we're here tonight. And I hope I've helped you do that. So thank you.